But why will the freshers lose this 10 marks? Why will the freshers lose this 10 marks?
The freshers, if they're teaching experience and applicants of other schools, they will also get.
No. Freshers. Fresh candidates. Not having experience. Why will they lose this opportunity?
They are fresh candidates. If they have teaching experience, they can get.
Those who have got teaching experience are not fresh ones.
Why should they include?
What I suggest,
Files are not here because date is
yes,
mentioned.
on this point, there seems to be a couple of matters. Now, I am representing for the untainted persons who in the last time, they thought they are untainted. They don't have to think anything about their life. Now we have faced it. So once it is decided either way, my lord, we want to say our view, because now it's they are seeking to challenge the, my lord, the statute itself, that prior teaching experience 10 marks, at what time it should be given. That's the law point.
No, not at what time. The entire thing is ultra vires.
Well, then fine, entire thing cannot be taken because Supreme Court has affirmed it. But in any case,
point has been decided.
No, not at all.
all I say today that
Not at all.
in the earlier entire proceedings, because I thought I'm an honest, I need not be a part of the proceedings. I lost my job. This time, my lord, I am so apprehensive. That's why I have made an application for additional party. Either way, lord.
All right. What is the application 2 and 3?
Lordship may add a skip.
Yes. Addition of party. Untainted candidates addition. You also same thing.
In similar,
You are challenging the rule.
but in my case, my lord, there is no classification of tainted, untainted.
All right. Please place your case.
Yes.
The opposition is there.
Pending, my lord. My lord, other
Yes, my lady. My lady, may I just add
so many requisition is pending in same point,
virtually?
and we also
May I
find
just add
requisition of
points here?
But I was
And there is
suggesting,
fixed on
yes,
same.
that's the reason I was suggesting.
One matter is there before the court.
Yes.
The council is present. Let us start.
My lady, I'm so sorry to interrupt. May I just place one point here, my lady? I appear also for the untainted.
Yes.
My lady, I also appear for the untainted. We are untainted candidates who've taken the exam successfully. But this issue, my lady, of this challenge of this rule has been previously decided by the Calcutta High Court by a division bench, my lady,
right.
upholding the rule and security requirement,
Very well.
giving
Yes,
past experience. So, for
All right.
instance, if you have
My lord,
as-
in the
let's take
meantime,
it into
the copies of the can may be given to us also. I'm not praying for an adjournment, but it may be given to us. We'll know that who are the applicants.
All right.
Receive one can for the commission.
One. Can
And we have received none. State has received none.
Well, according to, I'm sorry.
can one?
No, we have received all.
You've received all. The cans which have not been served upon the parties, please do serve.
Yes, but we may also get a copy so that we know
State can also
that what
be
points
served.
are being taken.
And the board is also there. Board can also be served. All right. Those who have not been served, please do. Yes.
My lord, the point arises, my lord, the background of this, let me tell you, my lord, there was an selection for appointment of teachers in 2016, which was set at not a whole hog by this Honorable High Court, which has been upheld by the Supreme Court. My lord, that's not the issue. Now, the Honorable Supreme Court, my lord, gave them liberty to go for fresh recruitment. Now, in the name of going for fresh recruitment, they have enacted new rules. That rule is under challenge, its virus is under challenge. The virus of these rules was never challenged anywhere before. The court has recorded in division bench the rules are not being challenged, therefore you are not interfering. Now kindly come to the middle of the rule. That is at page 32.
Yes.
This is of 29th of May 2025.
Why are you challenging it here in November?
No, the petitions are pending before this court for some time.
There are petitions pending, but you have not challenged it.
Yes. No,
Your-
you mean
Yes, 31st October.
my lord, several persons have not filed this petition challenging the virus of the rule. This is one of such petitions.
In November.
Yes. Anyway, but in November doesn't matter. That the challenging of virus does not depend on the particular time. Kindly see below what is these rules. These rules are below framed in by virtue of section 17 of the West Bengal School Service Commission Act 1997. I just take your lordship for primary satisfaction few of the provisions. The kindly comes to the provision of a selection of vacancy. This is very important.
Page.
Page 35, Rule 7.
All right. Information regarding vacancies.
Yes. The
Yes.
Commission of School Education shall, on being intimated by the West Bengal Board of Secondary Education, as and when deemed appropriate by the board, prepare a vacancy statement, vacancy statement of assistant teachers. Therefore, the teachers who are already there, they really are not getting any vacancy for them. And with the approval of the state government, send the same to the board. The board shall, with approval of the state government, send the category wise so and so and so. This is the creation of vacancy for fresh selection. Now, while fresh selection is made, then the parties should be treated, Milord, at level, at par. All the applicants will have the same benefit of getting the getting entry into the service. Immediately, my lord will find that in these rules, they have created a class amongst the class. Kindly come to the schedule. This is the educational qualification, including professional qualifications for selection of assistant teachers. Therefore, the educational qualifications are at the entry point fixed. Now, kindly come to page 42, schedule 2. Selection to the post of assistant teacher for class 9 and 10 shall be made on the basis of marks obtained in the written examination, educational qualification, prior teaching experience. If this is a fresh recruitment for the fresh vacancies, you are inviting the existing teachers to participate, along with the fresh recruits, fresh graduates, fresh entrants. Oral interview and lecture demonstration determined by the Central Commission. Written examination, OMR based 60 marks is common to all. Academics, educational qualification common to all. Then kindly come B, prior teaching experience, 10 marks. Therefore, this 10 marks is additional benefit to a particular group who are also equally applying for entry into the same process. Whether this can be done. This would be apparently and patently in violation of Article 14. And then oral interview and lecture demonstration. Now, lecture demonstration of the persons who are allegedly worked, though illegally, and the appointments were set aside by the Honorable Supreme Court declaring void. Another question would come whether they can be given the benefit of that so-called experience. This prior teaching experience 10 marks would violate the Article 14. You are creating a class among class. But this is the violence which I am challenging. Herein before, well, I must say, because I had the occasion to appear, petitions were moved by some group where the Honorable Division Bench says, since the rule is not under challenge, we are not interfering, giving certain reasons. Therefore, now the scope of this court, consider the violence of the challenge. Is that matter is still pending? And this is the petition where I am challenging basically on this ground that you cannot, at the entry point, create a classification. By that, you are trying to give advantage to the persons whose services were terminated. That's the intention. That you can come through back door. Giving 10 marks means all other new entrants will be out at the very threshold. Whether this can be done. This is the point.
Then, has the list of tainted and untainted candidates been published?
According to me, not. According to some, yes. The list which has been published, which I can demonstrate if Allah permits me from the Supreme Court judgment, is an incomplete list, again to protect a particular group. But I am not on that. I say that if the rule goes, then whether tainted, untainted, everything should go. At the threshold, everybody should be put on the same level without giving any additional advantage to X, Y, Z. That should be the compliance of Article 14 and 16 of the Constitution.
Show me the direction of the Honorable Supreme Court regarding this.
Copy আছে? না না যশা করে দিতে হবে।
সিঙ্গেল বেঞ্চে প্যারা 12 এই জন্য ডিভিশন বেঞ্চ আর বলেনি, সিঙ্গেল বেঞ্চে প্যারা 12 বলা আছে। যেহেতু একটা করেছে রে ভাই, সবই তো একই ব্যাপার।
Give me the number. It can be put on the screen.
Yes.
The officer, the number.
Judgment delivered on
Supreme Court.
3rd April কেন হার্ড কপি আনো না বলি কথা শুনি এনেছি কোথায় কাজের সময় পাও না এনেছি এটা রিপোর্ট রয়েছে তো এটা
2025 INSC 43
বলো ওদের
2025 INSC 43 এরাও 2025 INSC 43
তো করে বলি কাজের সময় ঠিক তৈরি থাকে না খালি মুখে মুখে তৈরি থাকে
আইপ্যাড থেকে দেখানো।
এটা রিপোর্ট হয়েছে তো
হ্যাঁ রিপোর্ট
তাহলে সেটা দিচ্ছ না কেন
2025 INSC 437
My lady, I have to interrupt. May I just make one point while my friend finds the papers, my lady? That the Supreme Court actually ordered the publication of the tainted and untainted lists.
দাঁড়াও তর্ক করছো কেন
And to publish the list of the
come to দিয়েছো দিয়েছো ওখানে এসছে
Page 35, Rule 7, you mentioned something regarding the vacancy statement of assistant teachers,
Yes.
right? Your submission is that since the teachers are already in service, the post cannot be treated as vacant. But then the entire selection process stood nullified. Then where is the question of,
that's to nullify
yes,
therefore,
though
they are
the
creating-
seats have to be treated as vacant only.
yes then how could you give
Yes,
additional 10 marks for teaching experience
to that teacher
this is a post for fresh recruitment fresh graduates at the entry point then you come as a fresh graduate but you cannot have the benefit of 10 marks for teaching experience. I am not considering whether this was void or not. That means you are creating class
that
amongst
I've got, that I've got.
that
followed.
you cannot do.
I'll
At
let
the entry point, whether there are Supreme
I
Court
have followed it.
authorities.
I have followed it.
পেয়েছো দিয়েছো সবকে well in the meantime may I read out
Yes, please read out.
the conclusion of Supreme Court judgment is paragraph 45.
এখানটা কমিশনকে একটু বলতে হবে
The last question relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates were appointed must be terminated and they should be required to refund any salaries or payments received. Since their appointments were the result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. The next paragraph. For candidates not specifically found to be tainted, who are claiming to be untainted, the entire selection process has been rightly declared null and void due to the egregious violations of illegalities which violated Article 14 and 16 of the Constitution. As such, the appointments of these candidates are cancelled.
31st October. 31st
However,
December.
the candidates who are already employed need not be asked to refund or restitute any payments made to them.
সেগুলো কি আছে আমাদের
Their services will be terminated. Further, no candidate can be appointed once their entire examination process results have been declared void. Therefore, the Supreme Court is very categorical that all the appointments having declared void, none of them could be appointed. There is no doubt in it.
All right.
And this violation of the rules was never challenged before. The division bench of this court said, recorded that since rules are not challenged, we are.
Division benches order, please.
This is
No, no,
division benches order.
division.
The division benches order I have handed over, my lord. Arunima Paul.
Convention is ordered now.
Yes, yes.
Your fifty now.
And
16 July 2025.
10th of July 2025.
Huh? So 16 July 2025.
In the matter of
Division benches.
16 July
Orunima Paul has been placed.
Arunima Pal?
16 July
It must be the same thing possibly.
Same thing.
16 July.
Same thing. 16th of July. Yes.
No, my lord, just before he,
Let him finish.
no, my lord, the writ petition, in the writ petition from which this appeal arose, my lord, there was a specific prayer, my lord, towards
challenging the
white.
firing.
And my lord, it was given up before the honorable single judge.
Whatever.
Let us-
Yes, you
let us
will
not-
get a chance.
Let us
Yes.
not go by the judgment of the court.
Yes.
Kindly come to page 24.
Yes.
Division bench.
Line from the
We order to
Yes.
continue.
The recruitment rules 2025 has not been challenged by any of the appellants.
Hmm.
In that background, the division bench order comes. That I know this specifically because I had the privilege of appearing before the division bench and
Yes.
Supreme Court as well. And then this order was appealed from Supreme Court, did not interfere.
All right.
But the point of why this challenge remains wide open.
All right.
And that's now I'm being conversing before the Lordship.
All right. This is all? Yes, Commission. It is your rule,
Commission.
that has been
State
challenged.
rule.
My rule, Malad.
State rule. All right.
Yes. Malad.
Yes, state.
Malad, I'll start by submitting that Malad, the learned advocate general has not been served, but I understand the bench wants to Malad look into the matter, Malad. So I'll address your lordship, Malad.
Please do.
Malad, Malad, the petitioner essentially is challenging the granting of the marks for the prior teaching experience. That is the long and short of the submission.
Yes.
Now, Malad, first your lordship kindly will take Malad the other batch of writ petition which was taken. If I may point out a singular paragraph of this honorable single judge's order, which thereafter traveled before the honorable division bench.
Order I have handed over.
Malad, a single bench I'm handing over. The same, Arunima Pal. Yes. Single bench for now?
Just 2 minutes.
Now, Malad, yeah, Malad, we have the copy of Arunima Pal writ petition also, para 12. We have the copy of the writ petition also, which clearly says in the prayer that the virus of the rules were under challenge.
But then the division bench is.
I'll say why this is coming. I'll say why this is coming. Can you take paragraph 12?
Yes.
Learned senior advocate representing other groups of petitioners at the threshold has submitted that prayer B of the writ petition being WPA 13457 is not pressed, wherein declaration is sought for to the extent that the declaring the rules of 2025 and the recruitment notification dated 30th May 2025 ultra virus. That prayer was given up. That is why the honorable single judge did not decide the virus, and that is from where Malad this submission is coming. Now kindly take the division bench's order. First, Malad kindly takes paragraph 28.
Yes.
In reply, Mr. Bikash Ranjan Bhattacharya, learned senior counsel, has submitted that the writ petitioners are not challenging the virus of the recruitment rule 2025, as their rights as untainted candidates are fully secured and has to be tested on the anvil of the judgment of the honorable division bench in paragraph 363 Roman 11 read with paragraph 49 of the judgment of the honorable Supreme Court. Now can I take the prayer of Arunima Pal? Give the prayer of Arunima Pal.
I'll give you.
But I'm giving a soft copy, Malad. Kindly pardon me, Malad. This is the prayer of Arunima Pal.
All right. What is
Where
the prayer?
the virus was under check. I'll read, Malad. Prayer B said that in Arunima Pal, a writ of and or in the nature of declaration declaring that the Kolkata Gazette dated 29th May 2025 issued by the office of the Principal Secretary of the Government of West Bengal and the notification dated 30th May 2025 issued by the Commission as being ultra virus to the Constitution of India. Now, Malad, this I believe is also filed from the same chamber that I find from the advocate on record's name, Malad. So, Malad, they are well aware that the virus was under challenge and it was given up by the before the honorable single judge. Though the submission, no, it's about being aware whether there are averments or not. Now, Malad kindly takes the constitutionality, whether the state was empowered to introduce 10 marks prior teaching experience or not. Now, Malad kindly takes paragraph 34 of the judgment. Division bench, page 22.
Yes.
The awarding of 10 marks is an weightage to be given on the basis of the experience, and it is only expected that in a selection process of this nature and kind, all the candidates are required to undergo the rigors of the selection process. In order to select the most suitable candidates, proportionate weightage based on the length of experience to the extent of 10 marks be given to such candidates is not arbitrary. The object is to select and appoint experienced teacher. As rightly pointed out by the learned advocate general and the learned senior counsel appearing on behalf of the commission, the appellants writ petitioners are not coming within the purview of the category in whose favor the benefits and concessions has been extended in paragraph 49 of the judgment of the honorable Supreme Court. They are not candidates selected in the 2016 recruitment process. In the meantime, they have not also applied for the service in any educational institute. Then kindly skips over a few lines to the next page from the third line. If we accept the submission of Vikas Ranjan Bhattacharya, learned senior advocate, then for the selection for the same subject, teachers, two different eligibility criteria has to be applied. The eligibility criteria in the selection process of 2016 is different from the recruitment process of 2025. The rules are more stringent and student-centric. The revision of the eligibility criteria, so and so then the NCT, that NCT also allows it is discussed. Then Malad kindly takes towards the bottom of that page, second last line. While the candidates with 45% marks in graduation may be eligible for the same subject a candidate requires to apply under the recruitment rules of 2025 would have to fulfill a criteria of 50%, and both of them, if appointed, may be a teacher for the same subject teaching in different education institutes. This will result in discrimination and a compromise of the quality. The prior teaching experience is an important factor, as experienced teachers may impart education for effectively and efficiently. The recruitment rules 2025 has not been challenged by any of the applicants. The delay, but this is where, that is why the single judge's paragraph was important. They prayed for it but gave it up. The delay in the recruitment, fresh recruitment, is due to the pending litigations, and when the opportunity for employment is opened by advertisement, it is always open for the authority to decide the eligibility of the other criteria in the academic interest for the benefit of the student. We accept the submission on behalf of the state respondent that there is no specific direction in the order of the Honorable Supreme Court by which the state is obligated only to fill up the declared vacancies of the first SLST 2016. All the orders relating to the issue had directed the fresh recruitment to be carried so and so. Then Malad kindly skips over to the next paragraph. If the government, 35, if the government felt that the experience gained by the candidates is relevant, the court cannot take a different view in judicial review. Similarly, prescribing any age limit for the given post and also deciding to the extent to which any relaxation can be given to the said age limit are essentially so and so. Well, these are on the other points which has been discussed. Then I am skipping over a few lines. Any process which applied equally to all the candidates and was designed to garner the best talent cannot be called arbitrary or irrational. The eligibility criterion in the recruitment rules 2025 is in furtherance to the object of finding the best available talent. The prior teaching experience has been considered by the division bench. It has been held that we are empowered to introduce it, and it is held that the court should not interfere in judicial review when the administration has thought it to be a fit exercise of their discretion, administrative policy. This point, I need not elaborate whether the prayer was there or not, whether it was given up or not. It was prayed, it was given up. As far as the state is concerned, it is issue estoppel. This point has been decided. This order has traveled before the Supreme Court. We have placed in several matters, and all the points are discussed here together because there were many other challenges by several petitioners. All my learned seniors assisted the Honorable Supreme Court. Your lordship, even assuming that there was no challenge, it's a fresh challenge, fresh batch. Who is ultimately what is the point? The point is, first of all, whether I had the power or not. Secondly, whether it's ultra-vires the constitutional scheme, whether it's creating arbitrariness is or not. But the power has been upheld by the division bench, then the Supreme Court, and the fact that it is not arbitrary within the campus of Article 14, that has also been discussed. But Supreme Court, I can copy.
Supreme.
I won't take soft copies.
No,
Yes.
Therefore, this point, your lordship will kindly not go into any further.
Yes.
Your lordship will not hear
But
the-
may I?
I will. Certainly, I will hear.
May
I
I
will
at one
hear.
point the government?
Yes.
My lords, may I assist my lady, my lords, by just making 2 or 3 points, my lords, if I may?
Just wait, madam.
Yes, very well.
Paragraph 6, page 4 of the judgment, which may have been placed, could have been placed. Paragraph 6. My learned friend Mr. Vikas Ranjan Bhattacharya appeared and what he argued. Mr. Bhattacharya submitted the finding, observation, directions about order to be strictly followed. That's all right. Mr. Bhattacharya further submitted notification, etc. Then will come. Further submitted that there has been significant change in the rules which would render the present applicant disqualified. It is submitted the prior teaching experience for 10 years was not an eligibility criteria in the earlier notification. Moreover, the percentage mark has been given arbitrarily and otherwise qualified. So much these are specifically argued. Please, see by Mr. Bhattacharya further argument. Please come to me at paragraph 24 of this judgment. Page 15. Mr. Bandopadhyay, the argument of the government.
Commission.
A commission was justified in awarding, has justified the awarding of 10 marks for prior teaching experience on the ground that it also extended to the teachers who have taught in such schools under Kendriya Vidyalaya Sanghan, etc., and training and other government-sponsored schools. Marks for prior teaching have been provided with a view to appointing experienced teachers who will be able to teach. Pausing here, Milord. Now, what Mr. What I argued here, because this teaching experience marks, 10 marks, are being given only to those unsuccessful candidates who have failed. It is not so. The teaching experience 10 marks will be available to everybody. Even the client applicants,
সেপ্টেম্বরের
if
অর্ডারটা
he has
এটা
got
পরে
teaching
রিজেক্ট করে
experience
দেবে
in other schools, etc.,
সেপ্টেম্বরের
he
অর্ডারটা
get
এদেরকে কন্টিনিউ করতে
admission.
বলেছে
Without the class, within class.
আমরা পোস্টটা যে
See,
ভ্যাকেন্ট
without the point. See, the teaching will be given to all who have, not necessarily to those who have appeared in the earlier first stage and failed. No.
পয়েন্টটা এমনি এখনো জোর নেই
This is
যত
wrong.
পয়েন্টটা আর্টিকেল
It was not confined to the candidates who had succeeded in the earlier first and thereafter been disqualified because of others' fault. This will be available to all. It made clear.
But why will the freshers lose this 10 marks? Why will the freshers lose this 10 marks?
The freshers, if they're teaching experience and applicants of other schools, they will also get
No. Freshers, fresh candidates,
candidates.
not having experience. Why will they lose this opportunity?
They are not best candidates. If they have teaching experience, they can get
Those who have got teaching experience are not fresh ones.
experience. Why should they include it? That is, is a teaching experience, that's what is being argued by Paragraph 24. The teaching experience have been taught in school under Kendra, Vidya, etc. Marks for prior teaching have been provided with appointing experienced teachers. That word experienced teachers, they will get the eligible points. What's wrong with that?
Why will the fresh candidates not be, or rather lose this 10 marks?
No,
This has been answered.
why don't you? Because teaching experience is a valuable qualification.
Yes.
Not all the applicants who can avail of this, provided he has no teaching experience. Now, is it argued that this qualification mark of 10, given for teaching experience, is bad? Or why is it bad? Why is that? Can you see paragraph 35?
34
Please tell me.
34 also sir 34 has answered the point
35, please tell me. And what the court said.
34 fourth line to answer
If the government failed, can you see me not paragraph? If the government failed, that the experience gained by the candidates is relevant. The court
কোনোটাই hard
cannot
copy আনিস
take
নি
a
তোরা।
different view in judicial review.
আরে বুঝেছি কিন্তু তোদের এটা ধরে
Similarly,
চলে তো হবে না
prescribing
সবকটা
any
কনসিডার
extreme
বিপদ হয়ে যাবে
over then it is all done by expert body. That is also mentioned in the document that these criteria have been fixed by expert body. And why the second interpret with them? Now, my lord asked a question, or then, but I'm happy in my lord. So why 10 months are these will be given for experienced teacher? Answer is that government values experience. And those candidates who have got teaching experience, they should be awarded by this marks because you get the teaching experience. That is what was argued. And not can you not come to the paragraph? This is if it has been taken the point, can the court say court cannot take a different view in judicial review? If the court, say if the employer thinks that the teaching experience is a valuable asset, for which can be given. It is why it is arbitrary. It is open to all. It is not that had there been teaching experience of only the first level failed should have been given. No, it's just not. Anybody can pick blood people who have got no teaching experience they have done. People who have got teaching experience, they are also going to that path. Now people have now these people with full knowledge of this qualification and taken mark have applied for and participated in examination already. Document goes that way. They have appeared, participated in the examination held in September, appeared there, and with full knowledge. Now, after having appeared, they are saying that you can just can't take that. List of dates to register, list of data. On the petition, I will go without. Copy,
My lords,
I'll show you a document
My lord.
of Supreme Court. They have appeared, participated, everything, with knowledge of this. At the time of appearance or the application, they have not taken any objection to this rule, knowing that they don't have anything in details. Try whether I meet it. Because the judgment, a large evidence cited of Supreme Court, that was modified by that of Supreme Court as that has not reflected. I think the judgment 17th April, kindly see judgment 17th April order of Supreme. Kindly see. Then I will give you list of dates. See that what Supreme Court says that we and
my lord will kind.
he may not. In this case, Supreme Court accepted the matter. Then the survey cited by Mr. Subjective was earlier done.
Yes.
Declined to accept the prayer made in the present application. In so far as it relates to assistance